On June 9, the OECD Working Party 3 on Cooperation and Enforcement will hold a virtual roundtable on criminalization of cartels and bid rigging conspiracies. We will hear from our delegates and we will benefit of a panel of experts, including Judge James Donato, Professor Peter Whelan, and Barbara Rosenberg. A recurring competition policy question is whether monetary fines against firms and other legal persons are sufficient to ensure deterrence. A related question is whether jurisdictions should adopt criminal sanctions in conjunction with fines and other sanctions imposed through civil or administrative proceedings. We have observed in the last year an increased adoption of different criminal sanctions across jurisdictions. Despite this increased adoption of criminal sanctions, there is no consensus on criminalization, and it has been observed also that integrating criminal enforcement in civil or administrative regimes often requires institutional and procedural adjustments. During the roundtable, we will also explore the different approaches to investigation and prosecution of criminal offenses, as well as to the role of leniency programs. Finally, we will look at how competition agencies could cooperate with prosecution authorities and the judiciary in their own jurisdictions. The OECD Secretariat Background Paper, which is available on the Roundtable webpage, aims at providing guidance on the benefits and challenges of criminal enforcement, focusing on custodial sentences against individuals. The paper describes the economic deterrence theory and the retribution theory that have emerged in the criminalization debate, and it offers an overview of criminalization trends across jurisdictions. Now, briefly on the two theories. First, under the deterrence theory, a sanction against criminal conduct can only be justified if it prevents or reduces future crimes. However, questions have been raised as to the concrete possibility to achieve so-called optimal deterrence through criminal enforcement, or as to the need to carefully assess what are the actual costs of prosecuting antitrust infringements as criminal conduct. Looking at the retribution theory, criminal punishment is simply justified by the fact that individuals engaged in a prohibited and morally wrong conduct. In essence, cartels are considered to amount to cheating or subverting the competitive process. Critics have been raised also against this theory. Just to mention one, it is argued that there is thin empirical evidence of society's moral condemnation or of the criminality of cartel. Now, even though there is an increased adoption of criminal sanctions said, there is no international consensus on criminalization of cartels, and in particular on imposing custodial sentences against individual offenders. Nor there is uniformity in the way criminal offenses have been designed across jurisdictions. This lack of uniformity may be due, among other considerations, to the fact that criminal law heavily relies on social norms which differ between jurisdictions. In addition, it cannot be disregarded that certain jurisdictions with criminal antitrust regimes lack strong criminal enforcement, with imprisonment imposed only in a few jurisdictions and in very few cases so far. The background note also identifies some key institutional and procedural questions to be carefully assessed when a jurisdiction considers criminalizing cartels. To mention a few of these questions, first, it cannot be disregarded that criminal antitrust sanctions trigger additional due process requirement. In fact, safeguards that are already in place for administrative sanctions may not be sufficient, particularly when custodial sentences may be imposed. And these additional safeguards could and would often increase costs of investigating and prosecuting antitrust cases or cartels. Second, criminal law principles may require prosecutors to meet a higher standard of proof, for instance, a standard beyond reasonable doubt, which is a standard of proof higher than the one required to be met in administrative and civil cases in the same jurisdiction. Third, another question that arises in criminal enforcement is whether and how to prove criminal intent, also called mens rea, which increases the burden to prove antitrust offenses. Looking at cooperation among different authorities in each jurisdiction, in the context of criminal enforcement, competition agencies may engage in reinforced cooperation with a number of different stakeholders. These stakeholders include, for instance, police officials, antitrust and public procurement authorities, prosecution authorities, and of course, judges. The degree of cooperation depends essentially on the powers conferred on competition agencies. For instance, jurisdictions differ as to the degree of involvement of competition agencies in criminal investigations and prosecution conducted by public prosecutors. Finally, the paper also looks at the effects of criminalization on leniency programs. And in this regard, the discussion on leniency has always recognized the fact that leniency policies do not operate in a vacuum. So, in the context of criminalization, it is essential to assess the relationship between criminalization and leniency. In this regard, there is an open debate which mainly concerns whether criminalization trends hamper or enhance the effectiveness of leniency, and in particular of administrative leniency programs. On the one hand, it is argued that sanctions against individuals, in particular criminal sanctions against individuals, can increase the effectiveness of leniency programs, as they may provide for a powerful incentive for individuals to reveal information about existing cartels and cooperate in the investigations. On the other hand, however, it is argued that criminalization may increase the efforts by these individuals to conceal such conduct, due to the higher risks that they may run, including the risk of being subject to custodial sentences. To address the potential negative impact of criminalization on leniency programs, several jurisdictions grant immunity from criminal charges to the first individuals reporting illegal conduct and cooperating with competition agencies. Other characteristics of well-functioning leniency programs are transparency and predictability. In a criminalization context, transparency and predictability translate into the certainty of criminal immunity for reporting individuals. A certainty of criminal immunity appears to be required or to require competition agencies to be in charge of prosecuting or being in control of criminal cases. So, the background paper concludes that a case could be made in favor of criminalization of cartels. However, not all enforcement regimes are currently built for successful criminalization. In fact, the note highlights the need for jurisdictions to gradually build institutions before introducing criminalization, and that each jurisdiction should determine the right mix of sanctions. The introduction of cartel enforcement also requires significant advocacy efforts by competition agencies. And finally, criminalization might require to rethink international cooperation, perhaps involving public prosecutors who are the ones entrusted with criminal law enforcement powers in many jurisdictions. We look forward to this discussion. Thank you very much.